Hi viewers, I am Dr.S.Chandra, Assistant Professor in Department of Commerce, Sri Sarada College for Women Autonomous Salem. Now we are going to discuss the classification and formation of a company. Before we are going to discuss the particular topic, first we know what do you mean by company. The word company has no strictly technical or legal meaning. It may be described to imply an association of persons for some common object or objects. The purposes for which people may associate themselves are multifarious and include economic as well as non-economic objectives. In common parlance, the word company is normally reserved for those associated for economic purposes, that is, to carry on a business for gain. In simple terms, it may be described to mean a voluntary association of persons who have come together for carrying on some business and sharing the profit therefrom. According to Section 2, subsection 20 of the Companies Act 2013, company means a company incorporated under this act or any previous company law. In other words, a company is an amalgamation of individuals who with a common purpose contribute funds and establish a distinct legal entity. So a company is an artificial person that is created by law and has a separate legal entity, perpetual sustenance, common seal and a limited liability. A company is a voluntary association of people who come together to contribute to the capital of the company to do their business activities. Then we are move on to discuss the characteristics of a company. We have so many characteristics, that is a distinct legal entity, limited liability, continual existence, ownership distinction, share transferability, common seal, legal capacity to sue and be sued, separate management, one share one vote principle. We discuss one by one. First we discuss the first one, distinct legal entity. Upon legal incorporation, a company obtains a separate legal identity independent of its members. It can hold property, incur debts and engage in contracts in its own name. Then limited liability. Under this, members' liability is confined to their contributions, protecting them from personal liability beyond their share value. This contrasts with unlimited liability in partnerships. The next one, continual existence. A company persists unless dissolved or it achieves its objectives. Changes in membership don't impact its existence. Ownership distinction. Company property is distinct from members' assets and a member cannot claim ownership of a company's asset. Then share transferability. Shares can be transferred subject to conditions allowing flexibility for shareholders. The next one, common seal. Essential for agreements, the common seal is the company's authorized signature ensuring legal validity. Legal capacity to sue and be sued. A company can initiate or respond to legal actions independently. Separate management. Here, management responsibilities lie with the board of directors, separate from shareholders. One share, one vote principle. Voting is based on the number of shares held, embracing a democratic process. Then we are move on to discuss the classification of the companies. We classified the companies on six bases, that is a mode of incorporation, liability, number of members, control, ownership, nationality. Under mode of incorporation, we will divide the companies into three types: chartered companies, statutory companies, registered companies. Under liability, we have to divide the companies into three types: unlimited liability company, limited by guarantee, company limited by shares. On the basis of number of members, we divide the companies into private company and public company. On the basis of control, we divide the companies into holding company and subsidiary company. On the basis of ownership, we divide the companies into government companies and non-government companies. On the basis of nationality, we divide the companies into two types, that is Indian company and foreign companies. Now we discuss one by one. First we discuss the classification of companies by mode of incorporation. Depending on the mode of incorporation, there are three classes of joint stock companies. The first one is chartered companies. These are incorporated under a special charter by a monarch. The East India Company and the Bank of England are examples of chartered incorporated in England. The powers and nature of business of chartered company are defined by the charter which incorporates it. A chartered company has wide powers. It can deal with its property and bind itself to any contracts that any ordinary person can. In case the company deviates from its business as prescribed by the charter, the sovereign can annul the later and close the company.